Former President Donald Trump is denying the latest allegation in his classified Mar-a-Lago documents case.
A new charge suggests you asked a staffer to delete security camera footage so it wouldn't get into the hands of investigators. Did you do that? It's false.
But let me tell you what.
Would you testify to that under oath?
I'll testify.
Would you testify to that under oath?
It's a fake charge by this deranged lunatic prosecutor who lost in the Supreme Court 9-0, and he tried to destroy lots of lives. He's a lunatic. So it's a fake charge. But more importantly, the tapes weren't deleted. In other words, there was nothing done to them. And they were my tapes. I could have fought them. I didn't even have to give them the tapes, I don't think. I think I would have won in court. When they asked for the tapes, I said, sure, they're my tapes. I could have fought them. I didn't even have to give them. Just so you understand, though, we didn't delete anything. Nothing was deleted.
Criminal defense attorney Jeff Brown joins me. Jeff, the president's given a number of interviews touching on a number of the cases that he's charged with, and of course we just heard him talk. Do you think it's likely special counsel is ordering every transcript and taping everything he says, that it could possibly be used at his trial? Because he's talking a lot about it.
I know, and of course what the viewers should know is that when the defendant, like Mr. Trump, President Trump, makes a statement, that statement can be used in court. And so everything that he says could end up in the courtroom. So yeah, I would think that if I was the prosecutor, I certainly would be recording everything that he ever says and deciding whether we're going to use that in the trial.
And of course, though, he can't use it offensively in trial because it doesn't get cross-examined, but the prosecutor can use it.
Right. So the defendant's statements can, if they're against his interest, if they're basically the statements that hurt him, they can come into the trial. But any statement that he makes that's good for him, he can't bring in because that's hearsay. So he's going to have that. But, you know, the general rule, as you know, is we don't want our clients ever speaking. And we certainly, it keeps us up at night if they do something like this. But I think a really good trial lawyer has to be like a pitcher. You have to be able to have all the pitches. You have to be able to do the change up, the slider, the fastball, the curve. And I think you have to adapt to every trial and prosecutor and judge. And I think in this case, and only in this case, something like what he said doesn't necessarily bother me as a defense lawyer because he's in fact testifying. And I think it's as powerful as if he was testifying at trial, but there won't be any cross-examination. So something like that doesn't necessarily bother me, but boy, I would be up at night waiting to see what else he's going to say in the coming days because he says the wrong thing. It's coming in as Exhibit A in trial.
You know, he says he's going to testify. See, that's what makes me cringe as a former defense attorney, is because, frankly, I don't care who my client was. I never want him to testify. I'd rather poke holes at the prosecution case because every time the client takes the witness stand, the client is 25 feet away from you. He hears something new and and there's not much you can do. He just sit there while he gets cross-examined.
I can count on one hand the number of times that I've seen a defendant actually testify and testify well. You know, I'll tell my client before we make that decision, and that's the last decision that has to be made, is the defendant testifying. He usually testifies last. But I say, listen, if we're winning, we don't need to win by 14 touchdowns. We just need to win. And my fear is that you get up on the stand and you say something and we lose it right away. So it's not about how much you win. It's just by winning. And I've just never really seen a defendant testify really well.
On the other hand, he's already telling the potential jury, though, he's giving his side of the story. I mean, it goes both ways. That he is previewing his case before any potential jury, and he won't have to take the witness stand.
Yeah, but on closing, you can get up there and certainly say, you know, my client was prepared to testify, but the government hasn't proven this case beyond a reasonable doubt. There's no need to. You don't need to hear from him because the facts haven't been proven. So you can kind of massage that through closing.
But I'm saying is that if he sits and gives out his whole defense in all these interviews, he never has to take the stand, and the jury's probably heard it. So I'm saying, you know, in some ways, it
is good, right? And in some sense, most of these jurors might have already heard him say that he didn't say that, and why get on the stand and testify? It's that unique defendant that he basically has such a platform across this country that he's pretty much getting to testify without a cross-examination.
Jeff Brown, thank you.
Thanks, Greta.